You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 82. Someone stole my invention and filed a patent application. Derivation Proceedings. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. In this episode, I'm going to talk about derivation proceedings. Let's say that you came up with an invention and you told your friend about it. You filed a patent application for it, and then all of a sudden, you see that your friend filed a patent application for exactly the thing that you told him about. And you know that your friend didn't really invent what he filed the application for. You're the real inventor, and he just stole it from you and is now trying to get a patent. That's what a derivation proceeding is for. What you're saying is that your friend derived what he is saying his invention is from you. Now, maybe they didn't steal it outright, but you worked on stuff together, and your friend filed an application and excluded you as an inventor, and filed his own application, and you didn't even know about it. So you should really be a co-inventor on the patent. And there could be other reasons as well, where other scenarios where derivation procedure is an appropriate procedure for you. Now, you might hear a lot about our patent system being a first-to-file system. The first person to file for a patent application has rights over other people that filed it later. It didn't used to be that way. It used to be that in the US, we were a first-to-invent system. So if you filed something second, but you can show that you invented it first, you had rights because you invented it first. And you still have to prove that you invented it first. But what was important is not who filed first, but who invented it first. Now we're in a first-to-file system, but it's not so simple as just first-to-file. It's first inventor to file. So you still have to have invented the thing. You can't just file an application first and get patent rights if you never invented it. There used to be a proceeding called an interference proceeding, which is what you would needed to do under the first to invent system. But since the US went to the first inventor to file system, some things had to be changed. So it's no longer an interference, it's a derivation proceeding. So how does this work? If you're the real inventor, you can't just file something trying to stop the other person's application from going forward. What you have to do is file your own application, get that on file. Once you have your application on file, you file a petition with the patent office to institute the proceeding, and you only have 1 year from the date that the other person's patent application becomes public. That person's application has to have claims that are the same or substantially the same as your own claims. Now, you can do all this in a regular court, later on, not with the patent office, but there are different rules and timelines, but I'm focusing on things dealing with the patent office itself. When you file the petition, you have to provide evidence with an affidavit that there is some communication between you and this other person who filed, showing that there was some type of derivation in there. Now, currently it costs $400 in fees to the patent office to do this, and that does not include attorney's fees. You have to submit what's called substantial evidence of derivation. Maybe you have emails between you and your friend where you told them about your invention, and your friend said, "Hey, that's really cool that you invented that. I never would have come up with that myself." That's pretty good evidence that your friend isn't the inventor. The Patent Trial and Appeal Board can do a few things. Maybe it will correct the inventorship. Maybe it will refuse to allow your friend's application to go forward. Maybe it will cancel the patent if it's already issued. The way that the Patent Office decides whether to agree with you and refuse your friend's application or cancel the patent is that there's essentially a mini trial, and it kind of follows the same order of things that I talked about in the previous episodes. Your friend can respond to the petition, ask to amend the claims. You can file a reply to your friend's response. Your friend can reply to your opposition. You present testimony. You have witnesses. Try to exclude evidence. Request an oral argument. At the end, there will be a decision by the Patent Trial and Appeal Board on who was right. Now, the whole time I'm saying your friend filed an application, but really, it could be anyone that stole the invention from you, and honestly, probably really isn't your friend if they're filing applications for things that you invented. I'm glossing over a lot of details that are actually pretty important that your patent attorney should know about if you ever want to do this, but I'm just trying to give you enough information so that if you think your friend stole your invention and they have filed their own application, that there is something you can do about it, but you have to go through the proper steps if you want to get this resolved. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, anything else related to your invention, contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.